Hiya, everybody. It's Kate Floss from the with the continuing with my various cases. I seem to be getting caught up uh, caught up in the courts, and just letting you know the progress of Catherine Sixtus. I'll just put in a just bit of a disclaimer here that there's been quite a lot of controversy about my name. And so I just want to clear it up for everybody that my actual true proper name on my birth certificate is Catherine Ann Sixtus. That's my name, Catherine Sixtus, Sixtus. The five Sixtus brothers were shipped out of Germany in 1843. They were instrumental in the bridge. Why are these people important? They are instrumental in the bridge they're instrumental in the bridge. I'll just adjust my thing here a bit. Instrumental in the bridge that the to the Queen Victoria when she was made queen. Even though she was made queen, she in the beginning did not have a Supreme Court status. So you have to be able. After she was coronated, there had to be a transition to almost either into the Supreme Court. Well, that was done right there in New Zealand, and it was done through the Chatham Islands of New Zealand. And originally, the Queen or the kings of England and of the United Kingdom were all German kings. Before that, they were French. And there was a transition period from King William IV, who was the last king, who was the king of Hanover, Germany, and also the king of the United Kingdom. Now, the transfer of that to Queen Victoria, where she became and established the royal family in their own right onto the lands of England, was done in 1843. Between 1843, there was the removal of King William IV, who was the king of Hanover and England, and there was in 1844 the ascension of Queen Victoria to be the Queen of England only in its own right. Now, that was done in New Zealand because it had to be done on a virgin territory, and that was done on the Chatham Islands of New Zealand. The five Sixtus brothers that were shipped out from Germany were never going to be allowed to return to Germany in their native status. And there's some things to do with shipping and the Admiralty law, and there has been a waka found on the Chatham Islands that they think is hundreds and hundreds of years old. Well, this was the waka that was used to row the persons onto the shore off of the ships. That's another story. Now, a lot of people, I've been accused of a lot of things. So this is just updating you on the court. So back to my name. My name is Catherine Sixtus. I had changed my name by deed poll to Caitlin Waterman. So Catherine Sixtus and Caitlin Waterman are one and the same people. And my stage name, a lot of people have stage names. There's nothing wrong with having a stage name. My stage name is Kate Floss. So I've got two Facebook pages that come under Kate Floss. I've got Caitlin Waterman is my is a name change that I made a few years ago for legal purposes. But my actual true name on my birth certificate is Catherine Ann Sixtus, and my new birth certificate that has Caitlin Waterman says on there that this Caitlin Waterman actually comes out of Catherine Sixtus. So they're one and the same people. Hope that clears that up for you. Now, if you go here to Reddit, you can look here. This is the there's been many articles, all right, that, there's been many, let's turn that off. That'll help me to maneuver around a bit, I think. Should be able to. There's been many articles produced in the few days, and most of them are just factually completely wrong. And so I wanted to come and clear up a few things for you so that you know where this case is going. It's saying on the headlines that the Maori Land Court judge rules that the German origin claim of the Chatham Islands waka is not plausible. Well, he did say that, but that is only half of what he said. And since then, there has been another in-chambers minute from the judge that has clarified this point. He's not actually, I'll let you read the thing for yourself, and you can make the judgment for yourself of what the judge actually said when he said that it was not plausible. So I'll get to that in a minute. So some of the things have been said. They've said that this is the Reddit, all right? And some of the comments have been, nutters like her should be prevented from making claims in the first instant, wasting the court's time. Now, this is the first thing that I would like to clarify for all of you people out there, all of my Kate Floss fans and all the people that are following Catherine Sixtus. This is a very high profile case, a high public interest case for the waka on the Chatham Islands. I'm here to tell you that I am not the one who went to the court to make this claim. And so I'm going to prove that to you right here, right now. I'll go to my bookmarks here and I'll prove it to you right here, right now, that this is actually not factually correct. Now you can see here what had happened was on the Stuff News. So Stuff News advertised, this is by Karanema Ruru, the waka remains found off Rikohu, which is this is actually not factually correct either. It's found on the island of Warikauri, a section on the beach, which is Department of Conservation land. I'm going to keep this a half-hour video if I can. What it says is that the Manatu Te Onga has issued a public notice on its website which gives interested parties 60 days to apply for ownership of the waka under the Protected Objects Act. So they asked anybody who wanted to make a claim to that vessel to write a letter to them and explain to them why you think that you have a right to make that claim. Now, after those applications were made, and I put in all of my evidences of the coordinates 44 degrees south, 176 degrees west, which is registered in the Supreme Court of Germany. Those coordinates are registered by John Ward, the Royal Britannic Magistrate, and the Supreme Court Magistrate, the highest magistrate in Germany, who I forget his name, who had said these coordinates, which are the exact coordinates where the vessel is buried, and that is what they've claimed. So I put that in, and I got a message. So they asked all of the public, every single person on earth, you don't need to be a New Zealand citizen, every single person on earth had a right to claim that vessel, all right? But nobody was bothered. But I was bothered because that Chatham Islands is important to me. So I made the claim, and that is my right. So after I made that claim, there was an investigation into all of the claims. And the Te Onga Ministry here said that it's on the Chatham Islands, and they said that there are 7 there were 7 claimants. Now, I'll see if I can make this bigger so you can see it, but I'm not sure that I can. I'll try and make it bigger. So you can see here, that's as big as I can make it. You can see here, there are 1, 2, 3, 4, 5, 6, 7 claimants, Moriori Emi Settlement Trust and Hokotehi Moriori Trust jointly. Ngāti Mutanka, they have not claimed ownership. They have only claimed to be an interested party. The Dix whānau, which included Vincent Dix and his son Nico Dix. The Keating whānau, Catherine Sixtus, that's me, Jodie Boyce and Maxine Williams. And it says the ministry has now completed our initial assessment, and we've received these claims, and that there are multiple claimants whose areas of interest cover defined location, that's me, and or simply have an interest in the case, that's certain other ones, and that the options for determining ownership, they've given these options, and that they've given the steps that we can take. So that was the last that I had made the claim, and I had expected to go through the processes. So the idea that it says here on the, well, where did it say it? On the Reddit. Oh, I'll just go back here. On the Reddit, where the Reddit had said others like her should be prevented from making claims in the first instance and wasting court's time. Well, before we get to wasting the court's time, should be preventing every person on earth, to that person there, every person on earth has got a right to claim artifacts if they think, even if you're just a citizen of the country, you've got a claim to be interested in any artifact. It belongs to any people that give a damn about it, and I gave a damn. These people on here, on this Reddit, did not give any damn about the waka. They were not interested in it. They could have made a claim themselves, and they did not. So it's just jealousy. You know, people are jealous. Now, they said that they're calling bullshit. Now, they've said that I should not have been allowed to go to the court. I'm going to discredit this as well. I did not make any application to the court. I really want to clear this up. And it's shameful that the Moriori and the Ngāti Mutanka have not made a public announcement that Catherine Sixtus did not make any claim whatsoever to the court. I did not. And I can prove that to you right here and right now. You can see it here. This is the application. You can see here that an application was made on the 8th of May, and the 8th of May an application was made, and you can see here that this application to the court was made by the trustees of the Hokotehi Moriori Trust at the Maori Land Court Te Waipounamu District. The trustees of the Hokotehi Moriori Trust had made the application to determine the ownership of the Tonga Tuturu, and the Moriori Settlement Trust jointly had made this application on the 8th of May. And because of the Ministry of Te Onga, because the Ministry of Te Onga had already done their investigation and already made the decision that there were 7 claimants. There are many laws to protect claimants until the claim is finalised. because the Moriori were going into the court to claim this vessel and the land area, they could not do that without including the 7 other claimants. So it is they who had called me into the court, and you can see it here. We were called affected parties. At the time, on the 8th of May, none of the people on their list were aware that the application had been made. The Ministry of Culture found out about how it's supposed to go is that the Ministry of Culture will conduct all of the investigations, and they will eliminate anybody who they think is not eligible to make the claim of ownership. That investigation did not occur because the Moriori had sidestepped the investigation and entered the Maori Land Court in an independent claim by themselves. So the Ministry of Culture were not able to conduct the investigations, and they would have had that investigation process occurred. They would have quite easily been able to eliminate me as a claimant, but because the Moriori had jumped ship and jumped into the court speedily, that investigation at the ministry did not occur. So the Ministry of Culture found out about this court case on the 12th of May, 4 days later. 4 days later. But I assume the Ngāti Mutanka also found out about it. The application also, Dick's whānau, they themselves are both Moriori and Ngāti Mutanka. So they sit on 2 fences. So these 3 groups here, the Ministry of Culture, the Moriori, the Ngāti Mutanka, the Dick's whānau, all knew about this claim. Do you know who did not know? The Ministry of Poti Heri Trust, who must give the certificates for excavation, they did not know. The Department of Conservation, they did not know. They probably knew, but they had not officially been informed. The Kitine whānau, which is 1 man, he did not know. Catherine Sixtus, which is me, I did not know. Jody Boyce and Maxine Williams, they did not know. We were informed about this court case on the 29th of May, all of us. And so we were ordered to go to the court by the court. Maori Land Court ordered us to go to the court on the 11th of June. Now, we also were told by the Moriori, which I'll tell you in another case, not now, that we had to submit all of any opposition to their claim, or any grievances that we had with their claim, or any witnesses that we wanted to call, had to be done by the 25th of September. Now, had I have not put in any opposition to that, I would have automatically lost my claim that was sitting over at the Ministry of Culture. So I had no choice but to put in speedily, as fast as I could, an opposition to their claim. What I put in was very, very speedily put in. I did not, and since then I've been embroiled for 4 months in a court case. So don't anybody be saying to me that that I wasted the court's time, or that I wasted the court's time, or that I was making a false claim. I was within my right, and I did not make the application to the court at all. So that is completely false information. Now, I want to dispel the information of what they're saying is that if you go to the many articles, so you can see many articles, you just type in Catherine Sixtus Maori Land Court, and you'll see that I'm on the RNZ. You'll see that I'm on, there are several, if I put Maori Land Court New Zealand, you'll see me on the New Zealand. This case very first came up by the New Zealand Herald, and this was done by Shannon Pittman. Now, I will just make a note of Shannon Pittman. I thought that she did a fantastic story, and she put all the information up for people to go and research. She put up the headline, which is perfectly acceptable, and it's acceptable that she has put up the headline. She said that the wakas was not plausible, but, journalists are not there to spoon feed you everything. Once the journalist puts the information up for you, it's up to you to go and research the various things that they have written and see, make your own evaluations. And so I would say that Shannon did a fantastic article. She really did. And what she's put all the information for you to go to, and what she had said, the Ministry of Culture, the Maori Settlement Trust, she's put all the information there, and you'll see me up there. But where I've said that she's put completely the information. What does she say here? The decision didn't provide any details about it. This is what she says. The decision did not provide any details about Sixtus's interest in the waka, and when contacted by NZME, which is New Zealand something, I declined to comment. Well, she contacted me, and she asked me if I wanted to give my view, and I had every right to give my view, and I chose not to. There were other appeals going on in the court that some of them I couldn't talk about, and certain media issues I had been ordered to take down, and I was a bit scared about what was going on in the court. I didn't want to disrupt the court, so I said to her no, that I would not make a comment, but she did actually offer to me to put in my side, but I had not, and was not able to, and still am not able to disclose everything, but I can disclose some things. But she says, and this is true because this is in the court's ruling, however, in her application to the court, she claimed the waka may have originated from the Hanseatic states of Germany. And that's what I have said, and that is what I stand by, and I have evidence of that. I have extensive evidence on that. I have said the most likely journey is that it was transported out of the port of Hamburg, or one of the Hanseatic states of what is now called Germany. Sixtus said this in her memorandum to the court, and this is factual. Sixtus said she believed the waka was carved by Sidney Parkinson. Now, Sidney Parkinson, it's very little known that actually the Te Papa Museum holds ancient New Zealand Maori carvings, and it was only recently discovered that actually in the Te Papa Museum, it actually does say that Sidney Parkinson is the artist that wrote down the plan for those carvings. And Captain Cook was, in fact, in over on Dusky Sound in the 1600s, and he did go and collect Germanic peoples from Germany and brought them to meet on his second voyage, and that he did meet Moi people in Dusky Sound. So not all of these things have been presented to the court. I've only been able to present very rudimentary because the court has not allowed any substantive hearings to take place. This is only preliminaries, and in preliminaries, we are not permitted to put in all of the evidence. We are only permitted to put in a general short piece on what our evidences might be when we do go to the court. So the preliminary analysis that I said, probability that the vessel, I have said that the vessel was made with New Zealand wood because we know that the woods are New Zealand woods exported by the High Chief to Germany, designed and manufactured by native Moi Moi Lutherans in Germany and Tahiti, and transported back to the Chatham Islands by the native Moi Moi and received by Moi Moi and buried. That's what I've told the court, and that is what I stand by. Now, what she said is, but in the decision, Judge Doogan found the assertion speculative and outside of the court's jurisdiction. He says, with respect, I do not consider it plausible on the basis of information currently before the court that this waka originates from the Hanseatic states of Germany, Judge Doogan ruled. Now, half of you have not probably even read the piece. He goes on to say, even if I'm wrong on the question of jurisdiction, I would not exercise discretion to grant the injunctive relief. So I'm actually going to go out of this. So this claim that the judge said that it is not plausible is, I really would like to deal with this. So after that, the court made a ruling, and we'll go to Judge Doogan's court ruling here. So in the court ruling, there's Catherine and Sixtus, right? In the court ruling, I don't need to read all of what he said, but this is on the Maryland Court's website, and you can actually go there and read it for yourself. I'll scroll down at the end of the video so you can read it. But in fact, I'll just tell you exactly what the judge did say. What he said was, he said that the jurisdiction is to hear only claims to ownership and custody of Tonga Tuturu, and he said that those are confined to objects that are Tonga Tuturu as defined in the Protected Objects Act, and Tonga Tuturu means that it relates to Maori culture, history, and society. We've got that because I already said that it was shipped by Maori to Germany, carved in Germany by Maori, shipped back to New Zealand by the Germanic peoples, then taken to the Chatham Islands. Now, he says, so we've got that bit, but he says it must have been manufactured or modified in New Zealand by Maori. Well, what had I said? And he said I did not fit this criteria because he says that I said that it was manufactured by German people and brought to New Zealand by German people. I had, in fact, not said that. What had I said? I had said the Ministry of Culture and Heritage and the applicants themselves have all expressed the probability that this vessel currently buried on the land, they call it CH744, has travelled across Polynesian waters. So I've said, yes, I agree with your story that it travelled across Polynesian waters, because obviously it would not have mattered where it came from. It's accepted by all that it does not come from the Chatham Islands itself, because it could not have, because the woods come from PAKKAHA, which is in the northern, furthest north of the South Island of New Zealand. These timbers come from. It could not have come from timbers of the Chatham Islands. Everybody's agreed on that. So therefore, All those waters around there are called Polynesian waters, and they encompass many, many, many countries. It's a huge area. So obviously, even if it was shipped down from Tākaka to the ass end of the Chatham Islands, it had to have travelled through Polynesian water. So this is a very broad statement that they're making. You know, it's broad. And so obviously, so I'm agreeable on that. Therefore, I said it makes it an international concern. The most likely journey is that it was transported out of the port of Germany or one of the Hanseatic states of what is now called Germany. And we can infer this because the John Ward Royal Britannic Commissioner's coordinates with the magistrate called Carl Sievkeen, he was the German magistrate, are 44 degrees south and 176 degrees west. Now, I actually think it's right on their, is it right on their claim? On the, hang on. I think I'm not sure if these coordinates may not be, they are here. So these coordinates are, look, these coordinates are 44 degrees south and 176 degrees west. That is put on there by the Maori themselves. They said it, not me. They said it in their claim. And you can see it right there for yourselves. 44 degrees south, 176 degrees west. And you can see the Royal Britannic John Ward document that is held both in Germany and in New Zealand is exactly the same, 44 degrees south and 176 degrees west. It's right there for your eyes to see. So how can it not? How did Germany have those exact same coordinates in their German magistrate court almost 200 years ago in 1841? These coordinates were gazetted in the Gazette, the German Gazette and the British Gazette. These coordinates were gazetted, and that is where the waka is. So you cannot deny this fact unless you're mad as a hatter. Not my hatter. My hats are good. Don't you worry about my hats. My hats are correct. So just to clear this up, and I have never said that it doesn't, I have said it is plausible that the carving design is possibly by Sidney Parkinson, because he is listed in the Te Papa Museum as being the designer of other New Zealand Maori artifacts. So that's why I said he possibly designed this one as well, because he was with Cook. The other one that I said, the wood was shipped to the Hanseatic states of Germany, carved and then sent back to the Chathams. Now that's another story. I'll tell you about that later, but not today. And what have I said? I have not said that it's not a Maori object. To be clear to all of you, I have never said that there's not a New Zealand Maori nor a New Zealand Moriori artifact. I have said that it is both a Germanic artifact and a Moriori artifact. So let's just be getting that clear. So I said it was carved and designed, and they met the moi moi and then sent back to the Chathams, where it was buried in the virginal cavity. So I said that the preliminary analysis of reasonable probability is that the vessel is made with New Zealand wood, which would include New Zealand Maori, exported by high chiefs to Germany, designed and manufactured by native Moi Lutherans, which are Moriori, in Germany, namely Tainiti, and transported to the Chatham shore by native Moi and received by Moriori and buried, making to vessel a New Zealand German object, tuturu, and a foreign object at the same time. So I said it's a Germanic object, it's a Moriori, it's a New Zealand Chatham Islands object, and it's a New Zealand object as well, because the woods come from PAKKAHA, which, by the way, PAKKAHA is listed as having a huge Germanic pre-1858 population. We're not talking about those Jewish Germans. They were not even German, who turned up in the 1960s or even the 1860s. We're talking far back before then. These were native people. Now listen to what the judge says. He said, these passages are illustrative of the position Ms. Sixtus is advocating. He says, with respect, so he's giving me some respect. He says, I do not consider that it is plausible on the basis of information currently before the court that this waka originates from the Hanseatic states of Germany. Well, if you can read exactly what I said, that it did not originate. I didn't never say that it originated from the Hanseatic state. I said that the high chiefs, there was New Zealand wood, so obviously it originated in New Zealand, and then it was sent to Germany by the high chiefs. So I've said that the design and the carving originates out of Germany. I did not say that the waka originates out of Germany, because obviously it's New Zealand wood. All right, so you've got to get all these. People are saying things that I never said that. So the expert evidence so far available all points to Polynesian origin. Well, they just don't, you can go and read what the reports say. They say only that it came across Polynesian waters. That is what they say. So I don't know. It's cannot. He answers his own question. It cannot have originated from Polynesia, because the wood is from New Zealand. So clearly the origin of the original waka is the trees of New Zealand out of Takaka, Nelson, New Zealand. The waka itself is designed and built outside of New Zealand. We know that because they didn't have the tools. And that's, you can read that easily in the Waitapu report. It's right there that the New Zealand Maori did not have the tools to do these kinds of carvings. And that is just the fact. But you can read what he goes on to say. He says two important things. He says the short point is that even if what she says turns out to be correct, so he in one sentence he says he doesn't consider it plausible, but right in the next paragraph he backs track on it, and he says even if it turns out to be correct. So he said it actually could turn out that she is correct. He says the court does not have jurisdiction to entertain her claim or grant the relief it seeks. Now, so you can hear what he's saying. He's saying it's nothing to do with whether her claim is truthful or not. Her claim might not be truthful, or it may well be absolutely truthful, but the court would not have jurisdiction, because it wouldn't be entirely a Maori object. It would be a mixed object of Maori and PAKEHA peoples. right? So he says, I can't rule on that. That's only one thing that he says. He says the court only has jurisdiction to tangata toru, and that tangata toru must be 50 years, over 50 years old. It must be created or brought to New Zealand by New Zealand Maori. Now, this is where the judge and I part ways, because it doesn't say that at all. It says that it must relate to Maori culture or history or their society. And it had to have been manufactured. It only has to appear to have been manufactured or modified by Maori. So if it was manufactured in Germany and modified by New Zealand Maori or Moriori on the Chatham Islands, in my opinion, it would fit this, but he says no. So that is the dispute. The dispute is not that he believes it didn't come from Germany, and I'll prove that even further to you. He then goes on to say, he says he would have no jurisdiction, but it gets even worse. He then goes on to say, for completeness, even if I'm wrong on the question of jurisdiction, I would not exercise discretion to grant the injunctive relief. So he says it right there. He says, I may well be wrong about the fact that it comes from Germany. And then he says, I may also be wrong about the jurisdiction. But if I'm wrong about those two things, I would still not grant the injunction. The only reason he says he would not grant the injunction is because it is the prima facie property of the Crown. So what that means is until someone gets the ownership claim confirmed, then the Crown has an interim ownership over it. So they are the only ones that could grant the injunction and not him. He says that is in dispute. So he absolutely believes that my story might be true. He thinks that he might be wrong on the jurisdiction. However, he has since made another ruling since I have appealed this, and probably because of the newspaper coverage. And I have said the judge, well, in my appeal, I said it's a bit unfortunate because it's a bit unfair. The judge read my appeal. That's over in appeals court. And part of the appeal is I said that the judge said that he could be wrong. And so that basically wipes out anything that he said. But he's since made another ruling that is not, it's been released to me, so I assume it can be put in the public. This is a judge's minute, right, at the Maori Land Court. And you'll see that this judge's minute was done on, this judge's minute was done on, I better let you see all of it. No, that doesn't help. Hope you can see that. So this judge's minute was done on the 7th of October, 2025. Now, I'm not going to go over all the things that he said because that's probably, I don't know, but I'm only going to go over this bit here. And he's written a special note to me because he said that, what he said is that by the decision of the 12th of September that you've just seen, I dismissed an application for the injunction brought by Mr. So he only actually dismissed the application for the injunction. I did so because I concluded, read carefully, he says that this court does not have jurisdiction to entertain the claims she is making. This court only has jurisdiction with respect to tangata toru, and then he describes the tangata toru. He says the claims by Miss Sixtus that this waka was made by people of German origin is therefore outside the jurisdiction of the court. So he no longer says that my claim is not plausible. He only says that if her claim is that the waka was carved by the Germanic people, and I'm not saying that it was entirely, if that claim is correct, he's basically saying if they had anything to do with it, then it's not Tongaturu. That is the dispute. He's saying it's not Maori. I'm saying it's both Maori and Germanic. He's saying it has to be completely and absolutely Maori and only Maori and nothing else. And so that is the dispute. So my claim is valid, and in practical terms, it says that she does not have standing because of that, because he says if she is correct, if the vessel is in fact a Germanic New Zealand Maori vessel, then then I would have no jurisdiction in this court. So I'm just wanting you to know the facts of this case. And he has said, now he even doubts this. There's even doubt in this ruling, because he goes on to say, as indicated in earlier directions, I will, as necessary, reconsider any remaining jurisdictional questions in light of the final archaeological report when that is available. What he said is, Miss Sixtus, that's me, along with, he says, how all this came about is because they're all going to a site visit tomorrow. And I had made application to be able to attend that site visit. And they have denied any of the other claimants any right to go to any site visits or to view any of the artifacts or to take our own pictures. They've denied any of us that right. But they've given that right to the Dinks Whānau, who were claimants. There's quite a story to tell about that, but I'm not telling it today. So they denied any of the other claimants other than the Dinks Whānau, who are applicants to this ownership claim. They have claimed that none of those other claimants are allowed to go to look at the vessel. And I'm saying that the vessel is being destroyed by them and that they are destroying Germanic DNA. I stand by that claim. Sue me if you want. They are destroying the artifact, and they are deliberately destroying any connections that it has to its Germanic connections, lineages. And I had asked the injunction that we could attend the site visit together with the other people, with the Dinks Whānau. And the court, that's why the court threw me out, so that they did not have to allow me to go to the visit. They're all going to that visit tomorrow. And I'm very upset because I'm not allowed to attend. The Dinks Whānau is going to have the Dinks Whānau have got a claim to this vessel. And they have got a private audience with the judge. And only the judge and one other person and the Dinks Whānau are going to go down to the site location. And I've said that that is a conflict of interest, that the judge should not be permitted to meet with any of the 7 claimants in a private capacity, or even in his judgely capacity without the other 7 claimants being there. So that I have complained about that. And that's what I'm upset about. And that's why I put in the injunction. It was not to stop any excavation. It was to say that there are discrepancies in everything that they've been doing, and a lot of corruption, a lot of what I think is corruption. And in practical terms, this means that Ms. Sixtus does not have standing to be a party to the proceeding now. But he said, this means that Sixtus cannot file papers, seek directions or orders from the court. Well, because I wanted to go to the Chatham Islands visit. And he said she may not attend the site visit, which is what all this was. They were happy for me to sit in the court as long as I was far, far away and did not want to go and investigate what they were doing. As soon as I made the application to investigate what they're doing and be able to go and view what they were doing, they closed me down in the court. And then as I indicated in earlier directions, I will, as necessary, reconsider any remaining jurisdictional questions in light of the final report. He says, in the meantime, this is what he says, and unless and until directed otherwise by a court of competent jurisdiction, I will not be responding or taking any steps with respect to memoranda or documents filed by Ms. Sixtus. So all of my documents and everything is in that court, caged in that court. He will not address any of them, and he will carry on addressing the other claimants, and all of my stuff is held within his court. There's many questions here because how would I take that and move it to another court of jurisdiction who are simply going to send me back to this court, because they're going to say your claim and everything is already in that court. So there'll be a huge conflict of interest for any other court to accept my case. And yet, this is just, I'm going to say that I'm respectful of the judge, and I really, truly do not want anybody to make criticisms of what he's ruled until the final decisions have not been made, not by him and not by the appeals court or anything. So we have to wait to see what happens before we go abusing. I'm not going to be abusing anything that they're saying, but I have said to the court that they have been unjust towards the other claimants, and that we've not been allowed to speak. So I've not been allowed to speak at the court. I've not asked the court to rule on any of this. I've only asked the court for the right to go there and speak. We've had, there have been, I think, 3 online Zoom court hearings, or maybe 2. There's been 2 on papers and 2 hearings. I've not been allowed to speak at either of them. And with anything that I've submitted, the judge have said, wait till February 2026. And I'll decide on that in February 2026 after the archaeological reports. But it's going to be too late for me then, because he is pushing a desire to excavate the entire vessel before 2026 and transport it off island, off the Department of Conservation land onto private land. And once it's out of the Department Conservation land, it's no longer owned and held by them. And that is what I've opposed. I have opposed the removal of the vessel from Department of Conservation land, which is owned by all New Zealanders, onto private land, which is owned by the Dix Whānau, and 3 containers which are owned by the Dix Whānau and Ngāti Mutanka and Maori. So that is why I have opposed its removal. And not only that, I'll show you in the actual court hearing that I was ordered to remove that from the from my YouTube, they've actually said in there that the artifacts that are held in those containers are being destroyed as we speak due to they were not correctly outfitted to hold these artifacts. And the artifacts are being destroyed, and I have proof of that. And so I had asked them to stop removing the objects from the Department of Conservation Land until they had correct containers that were owned by New Zealanders, housed by New Zealanders, outfitted with the correct facilities that they needed to preserve that which they were taking out of the ground. Those artifacts are destroyed now. We can never, ever recover what they've done. The site, I have proof, which I'll do in another video, not today. The site, I actually have proof by their own words that all of that vessel was deep within the cavity of the sand banks, the sand dunes, which were covered with New Zealand flax. The seawater did not go as far as that area, and that I actually have from their own words that they widened a creek bed to allow water to go into the sand dunes, and that is the cause of the erosion, which has caused them to remove 400 pieces. So it was only supposed to be 26 pieces. They've now removed 400 to 500 pieces and put them into containers that are destroying the microbes and DNA on those pieces. And the conservators themselves have said it's better to leave it in the ground at the moment because we don't have the facilities. So that's why I tried to put in the injunction to help the ministries that were trying to stop the removal of all of these artifacts. But the Department of Conservation themselves are, I've only just found out, the Department of Conservation are the ones, they widened the stream bed and they put in a sump down there, and the widening of the stream bed that they've said themselves is the cause of the erosion. And they've now had to pay $45,000 for an engineering team to go and fix the widened stream, to close it down, to stop the waters from washing in and destroying the dune site. Not only that, they got that engineer to come in and fix it before the judge's visit. We don't know if there's going to be photographs of the before and after. So before the judge's visit, we know that there was a stream. So when I had put in the injunction, the Crown and everybody came in and produced several items to the court. I've got those now. I got those because of the injunction. And so then they said, no need for the injunction now. And that they've thrown me out of the court. So there's many things that the public is not aware of that is going on down here. So how can you help me? The way that you can help me is to share this video and wait for updates. Please, please, please be respectful of the court. I've got no, the court can only do what it can with what it's handed. I'm respectful. I'm going through the court's process I respect the judge. I'm up against 10 lawyers. I'm up against 5 lawyers, and they all have an assistant. So 5 lawyers plus 5 legal assistants. I'm up against 10 lawyers, 3 huge trusts, 3 huge law companies. I think the Crown is on my side, actually. And I'm just trying to save the history of New Zealand. I actually am really trying to save the history of New Zealand from what is going on down there. What's going on down there is a travesty. It truly is a travesty for New Zealand when a very significant part of our history is being destroyed by them right now as we speak. So please be respectful of the court and respectful of the judges until we go through the processes. That injunction is now on appeal, and so I'm trying to get that done. Okay? I'm trying my best to get it done. Kate Floss signing out. And please share our video. I'm going to get a sailor's hat, but this is my best sailor's hat. Make myself look good. Well, let's just go through some of the comments to end with a joyous note. These are some of the comments that I've had on Reddit. Oh, yeah, for a joyous note. Here's some of the comments, if you want to stay for the comments. Nutters like her should be prevented from making claims in the first instance. Fake news, I installed a suppression device to block anyone going back before me. They're all making jokes. What's this say? Let's see. I really love this. I don't personally have any direct evidence that prehistoric Germanic Lutherans didn't travel to the Chatham Islands and retrieved a tree, took it back to Germany, carved it into a boat in the ancient Polynesian style, and brought it back to the Chatham Islands to bury it. But I actually do have that evidence. So I'll present more evidences to you. I have a lot of evidence, actually. People who have read my evidence cannot dispute because they can't dispute it. And I do have a Waitangi claimant, actually. I say go more classic Christian nutter, which the person in question seems to be. No, I'm absolutely Protestant Lutheran. And so it says, holy shit, I'd watch the Amazon adaptation. What else is... She said, there's a bunch of nuts who attribute literally every Maori archaeological find to the Norsemen, trying to hint that Maori were brought here by European explorers. Well, they were. From Germany by way of the Cook Islands. This guy's claiming that the Chathams were discovered by the Irish. Everyone knows that the word Aotearoa comes from the mispronunciation of that O'Toole, he's a rower. That O'Toole, he's a rower. I've said I have evidence of the German coordinates. Where are yours? So there's many. The idea that some dude on the Endeavour was so impressed by the waka design, when he got back to Hohen Watsit, he went and carved himself his own waka in the Polynesian style. The Polynesians did not have any carvings. That's the point. Polynesians never had carvings on their vessels. They used the coconut trees. Come on. You can't carve coconut trees. It's simply impossible to carve a coconut tree. So just know. with a stone and sailed it to the Chatham Islands, presumably where he buried it like a dog, saving their favourite bone for later. So somebody says it was Jesus' magic flying waka. He liked the Maori style. Yeah, so there's many. Let's go on over to, there's another one here. This is called Lemmy World. Can go on over to Lemmy World. Lemmy World is quite cool. What have they said? Lemmy World have said, Maori land court rules Germanic origin claim Chatham Islands not plausible. Lemmy World have said, what an absolute coot. The idea that raw materials would be shipped to Germany, a boat manufactured from them, and then the boat received on the Chatham Islands and buried, all without this being recorded, is absurd. Well, it was recorded. That's the information that all you don't have that I have. It was recorded. It was even gazetted in the German Gazette and the English Gazette. It was gazetted. The journey of the St. Pauli people going to the Chatham Islands, it's in the archives. It's in the Maritime News. There's a book written about this. Unfortunately, all of the history is written by German Jews, not by German Protestant Lutheran from Martin Luther or Luther of Germany. So actually, it all has been recorded, but the court has decided not to allow me to present it. It doesn't mean that the court themselves have said, I cannot accept this evidence of Germany in the Maori Land Court. He has not said that it isn't true. And he said he's waiting for directions from another court that does have jurisdiction. So I've got to go to appeals in the Maori Land Court. I'm going to lose that appeal. There's no doubt that I'm going to lose that appeal. I will then take that appeal to the PAKKAHA court, where they will either say that they would be able to accept the case or that this case sits with the Maori Land Court because they accepted it, and they should not have. They should not have taken my name and accepted it in the first place. So we have to go through those processes. So until that time, the Maori Land Court cannot look at or view any of my claim. So he's basically thrown it all out. But he's kept my name in there. See, he's not taken my name out of there. It's still there. So we're going to have two cases. It's going to be it's going to be black and white. It's yin and yang, black and white. One claim in the PAKKAHA court and another claim in the Maori Land Court. How's that going to work? What if the PAKKAHA court says that I do own it? What if the Maori Land Court says that the Moriori own it? How is that going to be decided upon? Are we going to have the Maori Land Court and the PAKKAHA court meet together in the middle of the air in the Supreme Court? I really don't know. It's the weirdest thing going on. So, give me a break, guys. I'm just Kate Floss with a high school for education, fighting 10 lawyers, 3 trusts, and a whole industry. I really like this one guy, Dead Beef. He says, it's worth reading the article to get a picture of who Catherine Sixtus really is. This guy says she sounds like a kook. I love this one. Batshit crazy is the phrase that came to mind. Oh, that's from Dead Beef. It sounds like I tried to fabricate an interesting story. Well, you can't deny the coordinates. I can't tell if these people are delusional, therefore need help, or if they're just shitty racists. Well, the racist game just doesn't fit. Call me racist. It doesn't work. And so that is the story. Those aren't mutually exclusive. Never mind that. They're calling me the nutty is a nut bar. Nutty is a nut bar. I tell you, I call those lawyers nut bars with what they're claiming. They've even, they've even changed their claim of ownership. They originally were claiming there's two kinds of ownership. There's traditional ownership and there's actual ownership. I'm claiming actual ownership. They originally did actual ownership and then they jumped ship and changed it to traditional ownership. So there's a lot of interesting things going on here. So I don't want your nasty comments. Please watch your tongues and watch your P's and Q's when talking of the court. If anybody be's nasty to the courts, we'll have to turn off comments. But you can be as nasty as you like to me, because I don't give a toss. I really don't. You can call me batshit crazy if you like. I know what I know. When you know, you know. When you know, you know. If you don't know, then you don't know. But I know, right? So there you go. Cat floss.